Hello friends, welcome to StudyIQ. Through this video, let's analyze the salient provisions of Maternity Benefits Amendment Bill 2016. See, this bill has been passed by the Parliament on 9th of March 2017. So let us see how this is relevant for our purpose. The bill provides for enhanced maternity leave of 26 weeks. See, this has been the catchy headline when this bill was passed by the Parliament recently. Now let us see what is in it for us. See, the earlier provision in the old Act of 1961 was a leave of merely 12 weeks. What is paid maternity leave, we will understand in just 2 minutes. First, let us see the difference. The 12 weeks leave was given under the old Act of 1961. Now, this leave has been enhanced from 12 weeks to 26 weeks. So, that amounts to 6 months paid leave. So, this is the difference that this bill, brings to the original act. Now this provision will be applicable only to the organized sector. We will also see the definition of organized sector for better clarity. First thing first, what is maternity leave basically? Many of you must be aware, but let me highlight for those who are not. The maternity leave is the paid holiday granted to a pregnant woman. See, when a woman gets pregnant, she needs to look after herself in a better way, and after the delivery, she also needs to look after the newborn baby. So this leave is granted in 2 shifts, that is 3 months before the delivery and 3 months after the delivery. So you can say 13 weeks before and 13 weeks after, for which a woman is paid for by her organization. Suppose before proceeding on leave, a woman is working in Infosys or TCS, or for that matter any other company. Now that company will, if that company was paying 50,000 rupees to the women before proceeding on leave, before proceeding on maternity leave, now that salary will continue even if she is not coming to work. So please bear this in mind. This will be of use to us in subsequent sections of this video. Now this is the crude idea of maternity leave. Paid holiday, it is granted to a woman. So now let's move forward. Basically this genesis of Maternity Act 1961 lies in directive principles of state policy. Now friends, you have to please when we are preparing for an examination, you have to see that we have to go behind the scene, what is happening in the contemporary current affairs, and also look into the constitution, because while we might be debating and discussing here the Maternity Benefit Act to the nitty-gritty down to every detail, but UPSC might go to the basic text of the constitution and ask you these questions. So prelims as well as mains, both points we will discuss. In prelims, they might ask you which is the directive principles of state policy which directly deals with maternity benefit. It is Article 42. Now the task for you is to go back to your Lakshmikant and see what this Article 42 deals with. Basically, there are 3 or 4 more articles in directive principles which deal with maternity benefit and child health care. Many of you must be aware of these, but still I am highlighting here Article 38. You can go back to your books, that is your dharma when you are preparing for UPSC, and then Article 42 as I have mentioned, and then Article 45. Now this is another important article because it a constitutional history to itself. Then what is the other article? This is Article 47. You can go and have a look at it. This is 47. You can go and have a look at Lakshmikant. And one more article I would like to mention, that is Article 39. So all these articles, they deal with women and child health care. Article 39, 38 we mentioned, 42 and 45, and then 47 can also be included in that. So please study the amendments related to these articles as well as especially Article 45. So guys, if pinpointedly a question is asked or you want to know which article specifically deals with women maternity leave, this is Article 42. So if the question comes, Maternity Act has been enacted under which article of Constitution, this is Article 42. So this was all. Now let's move to this. What is the need for amendments to the 1961 Act per se? Why are we bringing this amendment? The idea is that there is an ILO Convention 183 which deals with women maternity leave and other related things. So this ILO convention recommends, I am emphasizing the word recommends because it does not mandate, it only recommends the national governments like Government of India to provide a maternity leave of 14 weeks. 12 weeks we were already providing. This ILO convention, International Labour Organization Convention 183, only recommends, and the Government of India has not yet signed it, has not yet ratified it. Government of India is going to sign it, ratify it. So this is one reason that we needed an amendment to our own Basic Act of 1961. Now we are going ahead, we are going in a progressive way by giving the leave of 26 weeks, whereas this ILO convention mandates or recommends only 14 weeks of leave. So this is important for you to remember. Other reasons are that India's rank in GDR, Gender Development Report, and Human Development Report, and various other indices related to health, you can say MMR, IMR, women empowerment, these things, India had a shabby record so far. We could not achieve Millennium Development Goals to the extent we could have in the 15 years, 2000 to 2015, Millennium Development Goals were in force world over. India could not achieve its targets appropriately. Now this UNDP's Human Development Report 2015 says that women clock around 297 minutes of unpaid work daily. That is to say, women work for these 297 minutes, but they are not paid for by their employers, be it in our domestic homes. So this is the gap, whereas the same number for men is just 31 minutes. That is to say, men work, if the office hours are from, you can say 9 to 5, men work for 9 to up to 5:30, and they get paid for only 9 to 5. That is the rough idea you can have of it. So how is this going to improve this? So this is a huge, labor force participation rate difference. If we say difference between men and women, men are just not being paid for 31 minutes and women are not being paid for 297 minutes on a daily basis. This is a huge number. So how does this maternity amendment help this cause? The thing is, if we are not working if any woman is not working for 6 months and is on a leave and is being paid for this leave, then this will definitely be subtracted from this 297. So that is the reason this number will come down. 297 minutes will come down after the enactment of the new amendment bill, a new amendment to the 1961 Act. So let us move ahead. So let us now come to the key features of the bill. Key features of the bill include increase the maternity leave. It says we have seen already, like we have increased the maternity leave from 12 weeks to 26 weeks, but the 26 weeks leave is only confined to first 2 children and not to all the children that a woman conceives in her lifetime. So this we have to see carefully. 12 weeks leave up to 2 children, there is 26 weeks leave. That is for first 2 children, total leave of 1 year which will be paid for. This is a huge number. So 12 weeks leave for the 3rd child, and subsequently 6 weeks leave only for the 4th child. So this 4th child must be a poor chap here, because for his taking care of his or her birth, women will be having only 6 weeks. So that is a difference it creates. So in a way there is building up of inbuilt mechanism for checking the population growth. Since India is a democratic country, we are not like China where we can impose directly 2-child norm or anything. We are incorporating this provision which automatically discourages a woman from conceiving more than 2 children, because for subsequent births, for subsequent deliveries, the leave is decreasing, you can see. Now let us see the other features. It applies to units employing 10 or more. Now what does this mean? It says that every organization which employs 10 or more employees is an organized sector entity, you can say, organized sector entity. Now this definition of organized sector has been given by National Commission for Employment in Unorganized Sector. So it keeps on coming up with its report as to what is the status of employment in unorganized sector. What is unorganized sector by this organization? This is a Government of India organization. You can cite this. The unorganized sector employees are those employees for which there are no social security benefits. Social security benefits like no pension after retirement, no leave even for sickness, no guarantee of employment Today they are coming to work to the factory or wherever they are working. Tomorrow they might be shunted out without any notice. So there is a lot of insecurity amongst these workers. No standard pay and salary conditions, no leave, no maternity leave, no any sickness leave or for any other purpose, and then no provident fund deduction. So these are the features of unorganized sector employees. So this now for our purpose, Maternity Benefit Act has not been applied to unorganized sector. We will see this in the criticism. It covers adoptive mother and surrogate mother. Now adoptive mother is a mother who because of some reason adopts a child. She too has been covered under maternity leave. Suppose if she is working in any private organization or any government organization, be it a government bank or a government department, if she adopts a child, her employer also has to give her the leave of 6 months. There is a condition to it, provided the child being adopted is less than 3 months of age. You have to remember this. If the child is less than 3 months of age, only then can women avail of this leave. Adoptive mother can avail of this leave of 6 months maternity leave, and that too will be paid by her organization, Infosys, TCS, whatever the organization is, that too has to be paid. Now coming to surrogate mother, most of you must have seen that surrogate mother, this surrogacy bill has come in the last 6 months or so. So surrogate mother is a mother who conceives the baby for some other couple. So that mother too has been covered. So there is no condition, direct 6 months leave is there for this mother. No 3 months norm, the child baby should be 3 months old, nothing like that. No qualifier, 6 months leave directly. Now provision for crèche facilities, every employer employing 50 or more employees. Remember here the words are employees in first case as well. If the UPSC plays with you and lays a trap that it is women, don't fall into the trap, it is employees here. Similarly, provision of crèche facilities has to be provided to every organization employing 50 or more employees, not women. Crèche facility has to be provided at a reasonable distance for the baby of the women to be taken care of in these crèche facilities. So this crèche facility has to be provided in a reasonable distance, and women has to be provided to visit this crèche facility 4 times a day. 4 times a day. So this has to be the case. So 4 times a day, this is also strange. We will look into the criticism. Fifth point is awareness generation by employers. So when we talk about this thing, awareness generation by employers, it means that every employer under this amended Maternity Benefit Act, MBA 1961, has to aware the women, share the information regarding the fact that his organization is being covered by Maternity Benefit Act, and he has to provide the women with a paid leave of 6 months as and when she gets pregnant, in 2 modes. Now this information has to be shared with women in 2 ways. One, in writing, and it is not or here, and in digital mode, be it through email, be it through website of the employer or any other mode, so that employer cannot hide behind the fact that women did not avail, and women, so that's why it has to be made aware of this provision in the law being applied to the employer's organization in advance itself, at the time of signing the contract of employment itself. So let us move forward. Positive aspects of the bill are, it will help 1.8 million women in the organized sector. So around 20 lakh women, you can say 18 lakh women in the organized sector only. We will discuss this quite fiercely in criticism. Applicable to special economic zones too. Now this is important here. The fact that special economic zones are created for promoting the exports of a country. To these economic zones, no domestic laws whatsoever are applied, so as to enable the ease of doing business over here. No law whatsoever is applied to these except the CRPC or criminal laws. So they are not covered under pollution laws. What will happen by not applying them with making them apply with the various laws is that the cost of production would come down, and the goods produced by these special economic zones under these special economic zones would be cheaper in the international market. So India would be able to gain exports market for its products. So this many of the laws are not applied to special economic zones, but Maternity Benefit Act is being applied. So this is an important takeaway for you from prelims point of view. Please remember this fact, guys. A step to improve India's dismal health indices. We have seen that India could barely achieve. India was supposed to achieve a target of 40 IMR, infant mortality rate, under Millennium Development Goals, which expired in 2015. But India's rate was hovering at around 42 per 1000 live births. Infant mortality rate is the number of babies that die within 1 year after the birth. So that is maternal mortality rate. So India could not achieve this. Similarly, the case with MMR, you can have a look at some other source. I'm just giving you that this law will help in. Now with the enactment of this law, mothers would be able to better take care of their children, and mothers themselves would be able to have complete rest and take care of their maternity requirements. So this is a thing by way of which maternal mortality rate is expected to come down. Includes an inherent incentive for informed family planning. We have seen how from 26 week to 12 weeks and then 6 week, the leave keeps on coming down with every successive child. So this will help us in bringing down the total fertility rate. Total fertility rate is the number of children a woman gives birth to during her lifespan. So it is hovering around 2.1 in India's case. Total fertility rate for every woman. Every woman in India is on an average giving birth to 2.1 children for all the women in the India. That is what we mean by on an average. So this rate will come down if we have this thing. As I told you, we are not a dictatorial or a one party country like China. We cannot impose one child norm or two child norm. Democracy has to facilitate voluntary adoption of such measures. So this is what we are doing by way of this provision. Now see the negative aspects of the bill. This is important. We were waiting to discuss this. See, only organized sector workforce is covered. What I am talking about is Infosys employees, banking sector employees, those well paid jobs. They are covered under this act. But unorganized sectors, those who work, women, those who work in farms, who work in Manrega, who work in others, tea plantation gardens, who work in MSMEs, medium and small enterprises, and who work in cottage industries are not at all covered. Daily wage women laborers are also not covered. So this is, a kind of elite biased law. You can write it in your exam, elite biased law, to the extent that it covers only organized sector workers. They are already well paid. Their employers themselves are giving 3 months leave at least. So this is the biggest criticism, that while you leave aside 90% of the women workforce which is employed in unorganized sector, and cover only 10%, and that too the 10% which is already having some form of social security in the form of insurance, in the form of other facilities which are given by the organization to their employees. So the benefits under this act, the benefit under maternity benefit program will now be restricted to first-born babies only. We are talking here about Pradhan Mantri Matritva Sahyog Yojana, Janani Suraksha Yojana. Those who are aware of, under Janani Suraksha Yojana or Matritva Sahyog Yojana, the 6,000 rupees incentive was given for women's delivery in institutional facility like hospital, Anganwadi center or other such centers, where a woman could be looked after by trained medical professionals insofar as her delivery of baby is concerned. So now, earlier this benefit was not restricted. You can avail it for first child, for second child, for third child. But now this benefit is largely availed by unorganized sector people, unorganized sector women. Now this benefit has been restricted only to one child, whereas this has been extended. So this is an elite biased law wherein the organized sector is covered very well now. It was already covered, by the way, and unorganized sector has been left to fend for themselves, and the benefits that were already being given have been reduced by this amendment act. Remember, if the question comes in prelims, that benefits under maternity benefit program have been reduced by Maternity Benefit Amendment Act 1961 to 2016. Yes, this is the case. 2016 Amendment Act reduce the benefits to unorganized sector workers under maternity benefit program Pradhan Mantri Matritva Sahyog Yojana. Now, why this is important, why I was waiting to criticize it, because you see there has been a shift from the traditional role that women used to perform in rural areas or disprivileged sections of women hailing from disprivileged sections. They used to confine themselves to 4 walls of their houses. But with the intra-country migration increasing, as has been highlighted by economic survey, you can cite it in your answers directly in mains. Intra-country migration is quite high, more than what we expect it to be, what we think it to be. So men are leaving their traditional homes, rural villages settings, and coming to urban areas. So women are taking the dual responsibility towards their families who are in villages. They perform the tasks of a father as well. They take up the responsibilities of the father as well, and the traditional role of women as well. So not covering them under this amended Maternity Benefit Act is like a biggest irony of this amendment. So let's move forward. Puts entire burden on employers. We can see here that the 6 weeks leave, as I gave you an example in the beginning, that if a woman is availing of 50,000 rupees salary per month, if she proceeds on a leave for 6 months, then employer will have to chug up these 3 lakh rupees. Women is giving birth, father and mother are interested in child, employer has been made to act as a grandfather over here. So this is another lacune. How this affects the policy? The fact is, labor force is already skewed. NSSO data says that the labor force participation rate of women is 22.5% only. That is at any given point of time in India in a year. What happens is, out of 100 women of workable age, that is above the age of 18 years, only 22 or 23 women are employed. Rest 77% are rendered unemployed because of various reasons, like employers' preference to not hire women, like women's preference to not take up the job, and various other societal and economic biases. So considering this data that NSSO has, this is the latest data, you can note it down please. So NSSO data says that 23% of women are employed at any given point of time. Rest either by choice or by compulsion remain unemployed. So labor force participation rate will further go in favor of men after this, because employers, why would they pay 3 lakh rupees in case of our example for a child for which employer has got nothing to do with? So this entire salary burden falls on employer. Maternity the wages, maternity leave that has been increased, the entire burden is falling on employer, the company that is hiring the women employees. So the suggestion is to provide it to both men and women. If it is provided to both men and women, what would happen? Employers will have no extra incentive to hire only men. They will see that I will either ways I will have to provide the benefit to both men and women, then I would hire the efficient one, be it the men or the women. So that is the thing. So it will ensure equality. Other factor that comes to mind is that in many of the Scandinavian countries, they have something called maternity benefit fund, wherein the employer, be it the private sector company or plus the government, they both contribute to this fund, maternity benefit fund, and out of this fund, this requirement of financing the maternity benefit bill is met out of this fund. So burden does not fall entirely on the private sector organizations, and they don't have any inbuilt mechanism to not hire women. So this law is biased, and in Scandinavian countries like Norway or even in USA, this is the way they implement such laws. They don't put the entire burden on private sector corporations. So that is the way out. 2 ways we have suggested to eliminate the biases against women, that is provided to both men and women. Men could be provided paternity leave, what is called leave for a father to take care of his child or baby. So this is the thing. No mention of paternal responsibility in childcare and paternity leave. Now I would like to share something over here. See, All India Services rules, the one service that you are aspiring for, that is IAS or IPS. So under these rules, provision of paternity leave of at least 15 days is there. So government sector entities, they are well covered. Government sector employees are well covered. So they have a provision of 15 days of leave. Men can also avail of 15 days of leave to avail of their children, apart from 26 weeks of leave that they are being given now, the women employees. So if both the parents are working in a government in any of the All India Services or Central Civil Services for that matter, both of them are covered. But in this act, the paternal responsibility in childcare has been totally ignored. So this provision we should not have ignored. Women by way of this law have been again cast into the traditional role of looking after the family. Why can't men be made to do these jobs of babysitting? Why only women? So that is the essence over here. We are a progressive society where both men and women should take up the responsibility of rearing a child in a better way. This job should not only be left to women. Otherwise, what will happen? The number 297 that we discussed, that will go on increasing and increasing. We will have a gender biased society. So this is it. Now let us see other things. Critical analysis. What could have been improved? The Maternity Benefit Act of 1961 provided for benefits irrespective of number of children. Here we are seeing in maternity benefit, at least 12 weeks of leave was available for any number of children. But here what we have done, 26 weeks of leave for 2 children and so on and so forth, that we have discussed earlier. I will not repeat it over here. Then other thing is sharing of responsibility between employers and employees could have been envisaged, as we have discussed regarding maternity benefit fund. See, we have already created a Nirbhaya fund for security of women, on the under which the government puts rupees 1000 crore every year to be spent on ensuring security and safety of women at workplace and in public transport and various other public spheres. But can we not create a same fund on similar lines for maternity, for meeting the maternity benefit responsibilities? Why to put the entire burden on private sector? This is one thing. When we are talking about ease of doing business, especially, you can mention it over here. Lack of uniformity across labor laws related to maternity benefits. Yes, you see, there is Employee State Insurance Act 1948. You can look through it, 1948, and there is another act, that is Factories Act of 1948. Under these acts, different leaves are provided. This Maternity Benefit Act is not being applicable to organizations that are already covered under Employee State Insurance Act and Factories Act. These Factories Act also have the provision for maternity leave. This also has the provision for maternity leave. So under this, different leaves are given. Say 4 months is given, there 3 months is given. So what this amendment bill could have done is that it could have, incorporated a uniform provision of 6 weeks, 6 months or 26 weeks in these laws as well, and in All India Services rules as well. All India Services maternity leave rules are there. So these all acts could have been amended by the stroke of single amendment to the Parent Act and to these acts as well. But this opportunity has been lost, and different laws are being applied with different insurance of leaves to employees. So this is the thing over here. And now paternity leave and paternal responsibility has been missed out. As we have discussed already, that entire responsibility of looking after the baby or a child has been cast upon women only, women employees. Why can't women be, why should boys have all the fun, as we say in an advertisement? So that is the logic he is talking about here. The other thing that I would like to share is, this is not in the mainstream criticism, you can mention it over here, that we are giving 26 weeks of leave to women in organized sector, whereas our requirement under ILO was also just 14 weeks. Can't we have gone an extra mile and given the 14 weeks of leave to all the women, be it in unorganized sector, be it in organized sector? So this would have created a sense of equity and equality among disprivileged sections of society as well. And by doing this, this law could have been, saved of the criticism that it is an elite biased law. So we could have, created a semblance of equity also. Directive principles of state policy also tell the government, instruct the government to eradicate inequality in every form, amongst rich versus poor, amongst privileged versus disprivileged. Why this aspect has been missed out? We could have complied with, by doing this, we could have complied with ILO as well. Why go extra mile more than 26 weeks when you are leaving the 90% of the sector, unattended? So this is a lacuna, and you have also withdrawn the benefit under, reduced the benefit under Pradhan Mantri Matritva Sahyog Yojana. So guys, this is the entire criticism. We have discussed it at quite a detail, and we have made a very thorough analysis of it. But before ending, I would like to tell you that we have discussed this law, but please discuss Employees State Insurance Act insofar as its provisions are related to women, and the Factories Act, because UPSC is very tricky. We will be dealing with this law, or even Maternity Benefit Act 1961, the old one, but UPSC might go to these areas. So it is your bounden duty, the moral duty of a UPSC aspirant, to at least go through what is given in the first paragraph of Wikipedia related to these laws. So this is your duty over here. I am leaving you only with this task. I hope you like this video. In case you want to suggest for any further improvement in my videos and lectures, please let me know through comments under the YouTube section. So this is all from my side for this video. Thank you guys.